The Fourth Amendment is probably the most complicated of all the amendments we're going to cover. The Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrant shall be issued, but upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons or things to be seized. Really what the Fourth Amendment is protecting is our privacy. It's protecting us, ourselves, our houses, our papers, our effects, which are basically everything, from an unreasonable search and seizure. And we see this used a lot with police, with the government. Because remember, the Fourth Amendment, the Constitution, the Bill of Rights especially, protects us from our government doing stuff. So it's protecting us from our government, which is the police or the FBI or anybody in our government, from unreasonable searches. Now we know that searches happen all the time. So really the question becomes, what is an unreasonable search? We're not protected from all searches. We're protected from unreasonable searches. So that's something that we got to define. First of all, let's start with a term called reasonable expectation of privacy. And that is just simply everywhere that we can expect to have privacy, where it is reasonable to expect privacy, which applies in lots of things. Certainly our home, it's reasonable to expect that we have privacy in our home, that people aren't going to just come into our house and search our stuff or whatever. But it's also reasonable that we have privacy in our phone conversations, in our cars, in our, the pockets of the clothes that we're wearing, in our purses, in our cell phones, in our computers. I mean, anywhere that you feel it's reasonable that we have privacy, that's a reasonable expectation of privacy. And that's where police cannot search those things, or the government can't search those things without any reason. They can't make unreasonable searches. This is kind of important because, if it's unreasonable to search a person, if they have a reasonable expectation of privacy, then it's also okay to search someone if they don't have that. Well, where doesn't it apply? Well, let's look at a drug dog sniff. A drug dog, let's say, is sniffing the outside of your car. That's not a search of your car, because the drug dog isn't searching your car. The drug dog is sniffing the air around your car. It is not reasonable to expect privacy in the air around your car. It's no different than, let's say that you have cologne or perfume on. Is it reasonable to expect that scent that you put on you that morning is only for your enjoyment, that nobody else can smell it? Well, obviously not. That's not reasonable. The drug dog is not searching your car. It's sniffing the outside of your car. And we'll explain when they get a hit what that means. The same thing can go with garbage. The Supreme Court has ruled that garbage that has been left out on the curb to be picked up by the garbage collector, you no longer have an expectation of privacy. An animal may dig through it, like a raccoon or a dog may go through your garbage and scatter it. The wind may scatter your garbage around the neighborhood. Somebody might just be digging through it. It is no longer reasonable to expect privacy in your garbage. Now that changes if your garbage is in your house. Obviously, you don't expect those same things to happen in your house. So when it comes to this, should police search your garbage? Yes, it's called a trash pull, and police sometimes do that. They don't just randomly go through garbage, but if they believe that someone might be up to something, and garbage is put out on the curb for the garbage collector to pick up, they may look through that garbage, and that would be okay, even though it's a search of your garbage, because you no longer have an expectation of privacy of that garbage. It really depends a lot on the where. Here's the thing with the Fourth Amendment that's difficult, is there's so many what-ifs, and it depends. It may, that same garbage, if that garbage is in your house, well, then you still have an expectation of privacy. If your garbage is right up next to the house, then you probably have somewhat of an expectation of privacy. And so it really is difficult to determine this. To give like an overall standard here that is always followed. But there are some overall standards. Like, what is probable cause? Well, in order for the police to search, they need probable cause. In order for the government to search us, well, probable cause is a good reason to believe a crime was committed or there's evidence to be found. Actually, I'm going to give you a couple definitions. More than a hunch, but less than absolutely sure. for the government to have probable cause, they don't have to be absolutely positively sure they're going to find something. But it can't just be a hunch. I bet somebody has that, is not good enough for a search. So it's somewhere between those. There must be something articulable. Articulable means capable of being expressed, explained, justified. Let me use the example. We have the rule in our school that you can't have, let's say, coffee in class. So, well, let's say that someone has a mug, a silver mug, and it's sitting on your desk. And I'm teaching, and I have a hunch you got coffee. But I don't know for sure. That's just a hunch. That's not probable cause. If I walk up to you and I'm standing near you and I can smell the aroma of coffee coming from that mug, that's most likely probable cause. A good reason to believe that there's evidence to be found. Now, I may be wrong. Maybe there's water in there, but there was coffee in there previously and it still gives that aroma. That doesn't mean it wasn't probable cause. Or if you take a drink of it and say, oh, that's hot. That maybe is probable cause. It's articulable at least. If I searched because you said, ooh, it's hot, and I smelled coffee, why did you search this cup? I can give those two reasons. I can express or explain, justify why I did it. If I just said, it probably where a person would put coffee, that's just a hunch. Might be correct, but it's not probable cause. And it's important because police need probable cause in order to conduct a search. There are some exceptions to that rule, and we're not going to necessarily cover those in this class. In my law class, we get into that, but they're rare exceptions. Reasonable suspicion is more than nothing but less than probable cause. That may seem like a bad definition, but it's not enough to search. If police need probable cause to search, reasonable suspicion is not enough, is not that. But it's also more than nothing. So let's say that someone is driving down the street, doing nothing wrong. That's nothing. There's no reason to do anything, pull that person over or talk to them or anything. However, let's say that someone is driving down the street and in the middle of the night, not even driving down the street. Let's say that a person is parked behind a business at 3 in the morning, and there no reason for them to be there. That's reasonable suspicion. Police could come up to that person and say, why are you here? Maybe they're burglarizing the place. Maybe they're homeless and they need a place to go stay. Who knows? But it's more than nothing. It's not enough to search their car, but it's enough to investigate further. And that's really what reasonable suspicion is. It's enough for the government to investigate further and to hold a person for a limited amount of time. How long? I can't give you that either. I asked the judge once, and the judge said somewhere between 15 minutes and 48 hours, which is a huge discrepancy, depending on what's going on. So it's hard to exactly define what it is, but it exists. Okay? It exists. So it's not enough to search. Police need probable cause to search. Reasonable suspicion is not enough to search. What if police do search without probable cause? I told you that police need probable cause in order to conduct a search. That's our rule. Well, the exclusionary rule then would apply. The exclusionary rule says that any evidence obtained illegally can't be used in court. So if police would, let's say, go to your car and search your car for absolutely no reason, and they find some drugs in that car, that was an illegal search of your car, and that evidence should be thrown out of court. Now, there's a process that's called a suppression hearing, excuse me, and we're not going to get into that in this particular class. Again, if you're interested, take my law class. But the exclusionary rule would throw out any evidence that was obtained illegally. Essentially, it puts some bite into the Fourth Amendment. Without that, there's nothing really to hold the government accountable. But the fact that they lose evidence if they search illegally means that they're less likely to do so. The Fourth Amendment also goes on to talk about a warrant. Now, what a warrant is permission to search. And this permission has to be signed by a judge. And really what happens is that the government or the police would bring their probable cause to a judge. They don't have to physically bring it in, but they have to be under oath, sworn affidavit that says, hey, this is what we have. Can we go search this individual's house? Can we search their cell phone? Can we search their computer? Things like that. So it's permission for the judge to search, from the judge to search. And the search warrant must include the what and the where. What they're going to search for and where they're going to search. And you can't exceed those two things in your search. So let's say that there's some probable cause to believe that someone has stolen a TV. Let's say that an individual had been seen with a new TV. They kind of bragged about, hey, I didn't pay anything for this TV. And a surveillance camera caught someone that looks very much like them walking out of a Shopko, the back of Shopko one evening. Let's say a couple of friends said, yeah, this person has this brand new TV. He said he stole it. It's in the living room of his house. Okay, so all this information comes to the police. They take that information to the judge, and the judge says, all right, you can search the house for the 32-inch TV. Where can they search? Well, they can search the house. Where? Well, they can search anywhere where that TV could be. The what is the TV. Now, they can't search on the contents of the computer because the TV can't be there. They can't search in the desk drawers because it couldn't be there. They can't search in a shed in the back of the house, back in the back lawn, because that's not included in the where. They can only search for what they're looking for, where they're supposed to be searching. Now, if they happen to see something else, let's say they walk into this house and they're looking for this TV, and sitting right on the living room couch is some drugs and drug paraphernalia. That's in what we call plain view, and that can be taken. If police are in a place where they have a legal right to be, and they find something that they're not looking for, but it's in plain view, then that is a legal search too. So they can search for the TV, and they can search where the TV could be. Those things are specific in that warrant. Now remember, the Fourth Amendment said, no warrant shall be issued but upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons or things to be seized. That's what this is here. When is a warrant needed? Always to search a house. If you're going to search a house, police need to have a warrant, because that is where the courts say that we have the greatest expectation of privacy. And again, I said this before, police present the probable cause to a judge, and that judge then, if they believe there's enough probable cause, will grant that warrant to an individual. When it comes to schools, there's a lot more to the Fourth Amendment that I'm not covering. I'm giving you the very basics of it. And we can go more in depth in the question and answer class. But for this class, we're just going with the basics. It's protecting our privacy from the government. But let's spend a little time on Fourth Amendment in school. Schools fall under this doctrine in local parentage, which means in place of the parents. And for the most part, that the schools felt like they could search students if they wanted to search students, just like your parent can search you. And parents can give permission to have an individual searched if they're under the age 18. So let's say that the police pull over somebody who's age 17. They want to search that individual. They don't have any probable cause. They could call up the parents, and the parents could say, go ahead and search them. And then you could be searched. Excuse me. So the schools operated under that same idea. If they felt like searching somebody, their cars, their backpacks, they did so. Because while you were in school, the school is taking the place of your parents, okay, under this doctrine. We still kind of follow this today. Well, then came a very important case, New Jersey versus TLO in 1985. And I'm going to give you a real brief overview of this case. In class, I'm going to go a more in-depth version of it. I'm going to read something. So if you want more in-depth, if you're missing class, you want more in-depth, you can come get that reading from me. But the basics here was this teacher walks into this restroom, and there's two girls in this restroom smoking. And it wasn't allowed, obviously. So she takes these girls down to the office. And the vice principal asked the first one, were you smoking? And the first one said, yes, I was. So he gave her the 3-day, I think, out of school suspension. And then he asked the second one, the initials TLO, if she was smoking. And she said, no, I wasn't. So he takes her into his office, and she's sitting on one side of the desk and him on the other, and her purse is on the top. And she again denies smoking. So he grabs her purse and he opens it up. And what he sees right on the very top is a pack of cigarettes. And he basically accuses her of lying, and then he looks down in the purse again, and he starts searching through it. And what he finds is some marijuana, a list of people who owe her money, and some money. And basically it becomes pretty clear that she was selling drugs in school. So she was arrested. Well, she tried to get that evidence thrown out as an illegal search because they said that the school didn't have any probable cause, which is true. There was reasonable suspicion to search the purse. It's likely, if TLO was smoking, that the cigarettes would have been in the purse. But it's really just a hunch, because those cigarettes could have been, her friend might have had them. Maybe somebody gave her a cigarette in the hall. Maybe they had them stashed somewhere within the bathroom. There was no articulable reason to believe the cigarettes were in the purse. She wasn't stuffing stuff in the purse when the teacher walked into the restroom. So it was a hunch. So the search was a probable cause-less search. So this was appealed, and it went to the U.S. Supreme Court. And the U.S. Supreme Court said that students do have Fourth Amendment rights in school. However, they said that students could be searched by school officials if they have reasonable suspicion. So even though they said that students have Fourth Amendment rights, this is the first time they've really said that, schools can't just, for no reason, search a student. Teachers are not required to follow the probable cause standard that police have to follow. They have to follow a lesser standard, which is a reasonable suspicion. As searches cannot be excessively intrusive in light of the age and sex of the student and the nature of the infraction. Okay, so it said a couple things. Again, first of all, that students, you do have Fourth Amendment rights in school. However, that if the school has reasonable suspicion, not probable cause, just reasonable suspicion, that is reason enough for a school official to search a student. However, those searches cannot be excessively intrusive in light of the age and sex of the student and the nature of the infraction. This is an important case because we still use this as a standard today. Now, there's other cases that have occurred. Actually, lots of student cases, but this kind of sets our standard. This is a relatively quick overview of search and seizure. I tried to get it under 20 minutes, and I succeeded there, but by doing that, I didn't give enough time to really get super deep. If this is not sufficient and you miss a day of school, please come in and ask some questions, and I can go over some things a little bit more.